But I think what I've seen from you, kind of what and read is that you say that a sellable company, kind of that end goal is actually built by design, not by accident.
The biggest one, and I cannot say this enough, is your cap table. You need to know with certainty who owns what, why do they own it, and is it documented? So I've seen acquisitions fall apart or get significantly slowed down because a founder gave equity to someone informally, there was no written agreement, and now that person has a cloud over the deal. So basically, sum up, the question to ask yourself early is, if I walked away tomorrow, what happens?
Welcome back to the Search Bar, the podcast for law firm leaders who want smarter growth without the guesswork. Wine optional. I am Eric Ritter, the SEO sommelier and founder of Digital Neighbor. With more than 12 years of experience helping law firms scale, I'm here to have insightful conversations with industry subject matter experts so you can learn from them. And if you're ready to dominate in today's AI-driven search environment, check out my Motion for Marketing Success System. It starts with a free discovery call, no fluff, just a clear path forward. The link's in the show notes. And I'm really excited for today's episode. I'm really happy everyone's here because today we're diving into the life cycle of an entrepreneurial dream. From the first spark of an idea to the ultimate exit. We're exploring how foundational legal decisions made in the early days determine whether a company is a lifestyle business or actually a high value asset ready for acquisition. To help us navigate the complexities of M&A and startup growth, I am joined by Emmanuelle Subar Litvinov. Emmanuelle is a partner at the Entrepreneur Lawyers, a boutique firm that ditches the stuffy corporate vibe for a collaborative entrepreneurial approach. She brings a unique perspective shaped by 3 generations of family business roots, advising founders on everything from fundraising to strategic exits. Emmanuelle, welcome to the Search Bar.
Thank you so much for having me here. Excited to be here.
Can't wait here. I always like to surround myself with people that are smarter than me and really know their stuff. So, really looking forward to getting to the bottom of all of this here with you. But before we do, um, as the SEO sommelier, I always look for a wine that matches the spirit of our guest. You chose a Grishetto, which I might add is a brilliant choice for this conversation. For those listeners out there, Grishetto is an ancient Italian grape known for being thick-skinned and remarkably resilient, much like a founder needs to be. It's complex, has a great structure, and it's often used to add what people say backbone if you're blending it, which is exactly what a good corporate attorney does for a startup. So I'm really excited about this choice.
Well, thank you. And I absolutely love that pairing that you made. And honestly, thick skinned and resilient is kind of a job requirement, not just for attorneys, but for every business owner I've ever worked with. The life cycle of a business is unlike anything else. So I'm excited to, it worked out that it's thick skinned and resilient because you're making these consequential calls every day, often without perfect information, and having somebody in your corner who understands that pressure. And in my case, as you mentioned, who grew up and saw that pressure basically since, day one of my life, I can help you navigate it without slowing you down or standing in your way. And that's really what we're built to do at the Entrepreneur Lawyers.
Love that, Emmanuel. And I wanted to get right into it here with you, right? Because many founders, whatever that business might be, are focused on launching so much that they don't even think about selling until maybe it's too late because they're exhausted, right? You're exhausted. You've been putting in all this time and, spending, ditching the 40 hours a week job and now you're working 120 hours, right? But I think what I've seen from you, kind of what and read is that you say that a sellable company, kind of that end goal is actually built by design, not by accident. So with that in mind, what legal issues do you think what do you recommend that they should be thinking about early on if they want to build a company that's actually sellable down the road?
Yeah, that's such a great question. The biggest one, and I cannot say this enough, is your cap table. You need to know with certainty who owns what, why do they own it, and is it documented? So I've seen acquisitions fall apart or get significantly slowed down because a founder gave equity to someone informally, there was no written agreement, and now that person has a cloud over the deal. And buyers hate uncertainty. And then the second issue that comes up often is IP ownership, especially these days. You built a product with contractors, developers, a co founder who left, oversee VCs. You need to confirm that all of this work is actually assigned to the company and owned by the company. And it's not just verbally agreed to, you need it signed in writing because a buyer's going to ask. And if the answer is, I think so, that's going to be a problem and that devalues your company. And then third is your contracts. So client agreements, vendor agreements, key employment relationships, if any of those have change of control provisions, meaning a third party could potentially veto your sale or walk out the door the moment a deal closes. Those need to be identified and dealt with before you're deep into diligence. Your material customers need to be underwritten agreements. I once handled a substantial multi-million dollar deal where a lot of the material contracts were handshake deals because this company had been in business. It was a multi-generation business, right? Oh, the families go back generations together and nothing was in writing. And it was a PE company. We were representing the PE company buying them. And so ideally you have automatic renewals in those material contracts. And this is something consistently overlooked. If your top three clients are operating on handshake deals, buyer has no way to underwrite that value. And so recurring contracted revenue is what makes a business predictable, and predictable is what makes a business sellable. And then, very importantly, and this is something that does not get talked about enough, you as the founder, you need to be removable. And not because anybody wants to remove you, but because a buyer needs to believe that the business can survive without you. And if you are the company, if you're the one holding together every client relationship, making every decision, the single point of contact for everything, that's not a sellable business. So buyers pay a premium for these systems, for the teams, for a company that runs because of the infrastructure that you helped build, not because of, your heroics. So if you're extremely immersed, you better believe that you're going to see a significant earnout period. A lot of sellers obviously don't want that, but a lot of the purchase price will be tied to your continued performance post close, your retention of the clients, you're staying on longer than you wanted to. So to basically sum up, the question to ask yourself early is, if I walked away tomorrow, what happens? And if the honest answer is everything falls apart, that's your roadmap for what to fix before you ever run a process.
I love that. And, like I said when I was asking the question is, a lot of times people don't think about that until they're exhausted and tired, right? And then it might be too late to kind of take yourself out of the business, So kind of creating those processes, creating those systems early on. I think that's a fantastic kind of piece of advice there, Emmanuel. And you mentioned a couple things I want to dig into a little bit more of like what kind of those I guess pitfalls are, right? Like handshake deals, right? Like not people having equity but not having it written out. And I'm just curious, if you have maybe any examples or maybe even like one skeleton, right, in the closet that you've seen that kills a deal or can kill a deal in that 11th hour because, it comes out of nowhere.
Yeah, so that happens a lot more often than I unfortunately see, right? So I've seen deals where a founder gave away equity informally years earlier, never documented it. The person, whenever there's money involved, people smell money. There's
Of course. Yeah.
whispers of it, you hear about it. The person became hostile and it was a negotiation. It's not just, hey, sign this document saying you don't have the equity anymore, or it's becomes hostile. We had to settle with them. The current client, the client lost a lot of money, and otherwise the buyer walks, or you have a substantial indemnification holdback amount tied up, and so that millions of dollars can be gone if you never have that conversation put in writing.
Gary. Yep. So people get stuff in writing, right? Early on is important. And also, you mentioned, you're from which is very impressive, by the way, a three-generation family business, right? So I'm just curious how that background kind of changes how you maybe advise someone when they're, a lot of times with founders, you hear the word legacy, right? Like, how do you advise them on legacy versus maybe trying to sell an asset for liquidity?
Yeah, so growing up in a three-generation family business that's 103 years old this year changes everything, right? It gives you a completely different lens. You understand the emotional weight behind what someone's building. So as you said, it's this legacy, right? Um, so when a founder tells me I want to build something to pass on, I hear that differently than an attorney who's only ever seen deals on papers. And actually, it doesn't stop there. I'm married to an entrepreneur as well, who's basically been an entrepreneur his entire life, except for a few years way back when Smith Barney was still around. And he also grew up in a family business. Just that when I met him, that actually gave me pause because I understood the range of dynamics that can play out in a family business. I'm like, do I want to get involved in this? Because I've seen it up close. I didn't know what that family business was like quite yet. And they're remarkable, but they're complicated. And the legal decisions or the absence of them kind of have a way of compounding over time. And so, that legacy versus liquidity, I'm not just thinking about an exit multiple. I'm thinking about the governance, the ownership structure. What happens if a key person leaves? How do you protect what you've built without strangling the growth? How do you work around the dynamics that happen in a family business? Because there's a lot of dynamics. There's organizational behavioral um, counselors specifically for family businesses. And legacy is not just in a family business. It happens for any business owner who wants to create something, whether it's passed down to employees, which is happening a lot more often, which is, passed down to children. Regardless, people care a lot about their legacy. And so, I come in and work with them on how to build and how to protect and how to scale. And then if a founder is also purely focused on liquidity, get in, scale, sell, I'm still able to make sure they actually have the legal infrastructure to make that happen cleanly and efficiently. Because I built something great and I can sell it efficiently are two very different things.
That. And kind of on that note about kind of liquidity and money, I want to talk a little bit more about raising capital and raising money. Because that's something I think people are really interested in kind of digging into that because, especially, you know, understanding, why you might need legal counsel, why you might need an attorney on your side there from a founder. Because when you're raising, you're looking to sell, right? It can feel like a win, right? Like, oh, these people are offering me a lot of money, but I'm sure there's a lot of ways that that can go sideways, right? And you can just kind of lose control of the company that you built there. So just curious, when you're looking to raise capital or giving away equity, what are some of those mistakes that founders make that you see out there and that they should avoid, obviously?
Yeah, there's quite a few that come to mind, and actually, I've done an entire podcast just on this topic of the questions to ask prior to bringing in an investor. So I'll try to keep it concise here. The first is not being selective enough about who you take money from. Founders get so focused on closing the round, on raising funds, they don't think hard about who they're bringing into the business. A bad investor could be somebody who doesn't understand your industry, has unrealistic return expectations, or starts micromanaging you at the first sign of the slow corridor. And that can make your life miserable, impede your growth, forces you to make decisions you wouldn't otherwise make. So your cap table is permanent. That relationship is permanent, treated even more serious than marriage in many instances. Actually, last week I had it's a little bit harder to get out of, but I just last
Yeah.
week I had a client come to me bummed out because someone decided not to invest. So I was having a conversation with them asking, what bothered you about it? It wasn't about the business. The person just didn't understand the structure. And it was a more complex structure. But meanwhile, the client has a number of other investors specialized in that field who are excited, who get it, and who would make genuinely great passive investors. And so we did have the conversation. Not everyone is the right fit. Not everyone is going to understand your vision. And that's okay. And sometimes that rejection is a filter that's working correctly because you don't want that person on your cap table who doesn't believe in what you're building. That's just a headache waiting to happen. And so, we without saying, "Hey, is your ego getting in the way?" We got to the conclusion that it's an ego thing, which is fair. Nobody likes hearing no, but the right investors are worth waiting for. And this one still had them lined up. So that's the first one. The second one would be not understanding the term sheet beyond the valuation number. So founders see a number, we raised $10 million valuation, but what did you give up, right? They gloss over the provisions that actually govern their lives for the next several years minimum. So liquidation preferences, pro rata rights, protective provisions that give investors veto power over your decisions. Um, I've seen clients who came to me afterwards, but they signed documents essentially meaning that their investors excuse me, that essentially meant their investors got paid out first in an exit scenario, regardless of what the company sold for. So they didn't focus on what was actually going on. You just focus on the shiny big number. But that happens so often because the founders get scared. The founders say, we need to raise funds. I need to pay my employees. I can't hire an attorney right now. I'll hire them after I have the money. But they don't understand everything they're giving up. And that does lead me into my third one, which is not understanding dilution. So a lot of first-time founders, and I've seen this so often, they think raising money is purely additive. They don't really think through what happens to their ownership percentage over multiple rounds. So let's take a typical founder. You have a seed round, a Series A, option pool grants, convertible notes converting at a discount. So that founder that started at 100 can end up in a seemingly very tight spot. And it's not always obvious in the moment. And oftentimes they think, each round is reasonable. So this makes sense here, but it's only when you zoom out and look at the full cap table, you realize how much you've given up from the cap table to the decisions, etc. And so again, one of them, I've had unfortunately quite a few who came to me afterwards, but a founder who did 3 rounds before we started working together. Smart person. Like, these people are typically smart people, great company, but just certain situations that arise, where they make these promises. Sometimes they make promises for equity that doesn't get put into writing. And so we try
Mhm.
to address
Right.
those early as well. And so by the time we map it all out, side letters here, side promises there, he owned significantly less than he thought. Not catastrophic, but it definitely was enough that it changed how we thought about exit options, which might
Mm,
have been, they were like 5 years down the road. But we had to start planning them from now of how do we do the next round? How do we progress you to make sure that we don't dilute you further? How do we protect your rights so that when we do go to sell or, whatever we end up doing, some sort of exit strategy, that you get what you deserve to get. Deserve is I don't know how I feel about the word deserve, but you get something for it. So that's the conversation I want founders to have before they sign these documents, before they make any verbal promises, not afterwards.
yeah. Thinking ahead, right, is kind of the key there and not after, right? Because hindsight's always 2020, kind of thinking ahead. I think it's key. One thing you mentioned there a little bit is kind of the equity split, and I just want to dig into that a little bit more because you've worked obviously with industries across the board, whether from tech to wellness, and what even is a standard equity split, and how does that maybe change? When on the one side you might have the founders, the face of the brand, or maybe a software product on the tech side. How does that really change that standard equity split that we talk about?
So I don't know if there's there's no one size fits all standard equity split, if that's what you mean by bringing in partners or bringing in other
Yeah.
people. Whatever value they bring in, it tends to be, okay, what makes sense for you as a whole together? And so that can look like a variety of different options, from straight up 50-50 to different types of voting mechanisms, to say on certain components you deal with operational, you deal with IP, and split like that. But from, you mentioned two things. So number one is that standard equity split, and number two is the different industries. And so different industries, the split can look different because, let's say wellness, let's say the founder is the brand, or a co-founder is the brand. Um, Personal brands, service brands, anything where the customers are following that person, the buyers, especially in an M&A deal, are going to be concerned about the key man risk. We talked about this with, if you are the business, right? What happens to this company if the person leaves? Does the value walk out the door with them? So in those situations, you often see the earnout structures, the longer transitions, they might get more equity when you're forming the company because they are the face of the brand, right? And then buyers will also include stronger non-compete provisions, ones that are much more aggressive than you'd see in, let's say, that tech or software deal. So a founder does need to understand that upfront. And you're not just selling the company or operating the company, you're often selling yourself in a structured role for a period of time. And that will affect your valuation multiple as well. So buyers tend to build that risk into the price. If you're focused on the equity, that person might receive more equity. But if there's one person doing more of the operational components behind the scenes, and then one person's the face, it's a conversation of,
Yeah,
how do we
yeah.
split this? How do we make it equitable? So even if you're not planning to sell, you're building that brand that lives beyond you. You're training your team, you're systemizing your client relationships. You're doing what you can to make sure that, again, it's equitable across the board and the work pays off at the closing table.
So I want to talk a little bit more about your firm when it comes to all of this, right? Obviously, you have a lot of expertise. Your firm has a lot of expertise, but you guys, as a marketer, I think this is great. Brand yourself as anti-stuffy, right? And because in your world, it's really about hourly billing and those really rigid hierarchies. You're looking and you've opted for a model that feels much more like a partnership, kind of that advisory role than a vendor relationship. So, how does kind of acting as an outside general counsel allow you to kind of step in and help them as a partner spot those legal risks before they snowball, maybe even become lawsuits or even worse down the road?
Yeah, of course. And actually, we are working on subscription models, kind of like concierge doctors, which is now a thing everywhere. We're working on that kind of
Yeah.
subscription basis, and also flat rate models that we're hoping to roll out Q4 of this year, just to kind of have that more partnership relationship, because people hate the billables, right? The clients do, the
Right.
attorneys do.
Yeah.
So we're working on really creating that partnership that you just talked about, that we truly
Yeah.
believe in. Well, the difference between outside general counsel and transactional work is that we're in the flow of the business. We're not just brought in at the critical moment. Um, 99% of my clients have my cell phone number, to where they pick up the phone, they can just ask me a quick question and move on with their day or something. Or, hi, I'm on a call with another, with this vendor, is this okay? Right. And because I understand their business and I know what's going on and I know the contracts we've entered into, I can be that partner with that for them. And from the beginning, I really like to learn my clients' businesses, not just the legal documents. It's not just a contract in front of me. I like to know how they operate, who they are, what actually matters to them, who is important to them, from their customers to their vendors, what relationships do they prioritize. Is that who they should be prioritizing, and having a conversation about that? Who do they work with? What are their commercial relationships actually look like? Because that context is everything when I'm reviewing and negotiating, so that I can also better protect them when I come to the agreements, and there's less back and forth. I'm much more efficient because I know, okay, this IP language is going to put them at risk with this other agreement, or there's a conflict here if they're about to sign an exclusivity provision. This happens quite often, of, somebody puts in an exclusivity provision in an agreement that shouldn't be there in the first place. But, for negotiation purposes, if you don't cut it out fully, you redline it a bit, but you need to make sure that you just don't put your client at risk of breaching it the second they sign, because of all these other deals they either have in writing already active, or that they're discussing and that you're aware of the discussions, even though the agreement hasn't hit your desk yet. Because I'm aware of the discussions, I can say, if you sign this way, this will put the other agreement at risk. So what would you like to do? Would you like to carve it out? Would you like to have a conversation? So being able to fully have that big picture while addressing all the small minutia of it. And so yeah, we talked about AgP, we talked about healthcare. It's really understanding. It's having us in your back pocket. It's as if having an in-house GC, but you don't need us all the time. It's having that person you can just call and ask that question to. Oftentimes it's not law. There's employment issues that come up of behavioral organization, of I have this employment issue, what do I do? I have this issue with a partner, what do I do? And so in a sense, you're lawyer/therapist sometimes, but it's part of it
Right.
because it really gives you this deep
Yeah.
understanding of the business and the dynamics so that when issues arise, you can just address them head on very efficiently. And it creates such a great long-term partnership. So all my clients there's very rarely I have like a one-time document to do of, hey, I have this one document, can you review it? And I never see them again.
I love that. I also saw that you're an IMF fellow for the Florida Bar. First of all, can you tell our viewers, listeners, what exactly that is, and how that maybe impacts your knowledge of kind of what's in the pipeline and kind of maybe what changes are up ahead?
Sure. So IMF stands for Inclusion, Mentorship, and Fellowship. It's a committee which is part of the business law section of the Florida Bar that provides those three things to a lot of the young professionals in the organization. And so I'm honored to be a fellow. I applied. I've been a fellow for the 2025 to 2027 2-year period. And so part of that is so the things that tell founders to have on their radar right now, they're all moving in the same direction. The policy environment is actively being restructured to make it easier to raise private capital. And founders who understand that can position themselves to take advantage of it. So one thing is the Invest Act. It's a big one. It's been passed by the House. It's working its way through the Senate. It's one of the most significant bipartisan capital market legislations in over a decade, and it's specifically aimed at modernizing and democratizing access to U.S. capital markets, which it will simplify exempt offering pathways. It's a few different offering pathways. So this will simplify the exempt offering pathways. It will expand who can participate in private raises, make it easier for companies to stay private longer while still accessing meaningful capital. And if that passes, it actually changes the fundraising calculus for a lot of growth stage companies, which is a big part of the types of clients I work for. And then the second thing is the accredited investor definition itself. So the SEC rulemaking agenda includes initiatives to expand who is an accredited investor and the pathways, which broadens the pool of people who can legally invest in your private offering. And so that is significant for founders doing what's called Regulation D raises. And so I'm trying to keep this kind of concise because SEC private securities compliance is a whole different thing.
Right. Yeah. Yeah.
Whoa. But more eligible investors means more options, means more people you can raise capital from, especially outside traditional, VC networks. And then a big one, um, dealing somewhat with private securities, but still relevant, but in the corporate transaction side as well as the the qualified small business stock, QSBS. It was part of the One Big Beautiful Bill. It was not only preserved in the 2025 tax legislation, but expanded as the cap increased, the individual benefit cap rose, a lot of really great benefits to it. And if you're a C Corp, or if you're interested in being a C Corp, or your early employees or investors didn't know about it, you're potentially leaving a significant tax exclusion on the table. And since that bill passed, I've worked on maybe just 5 to 10 reorganizations from LLC or S corps to this C corp to help take advantage of those tax benefits. I tend to work very closely with some great wealth managers, tax attorneys, estate planners. If those three people are not telling you about QSBS, then have that conversation with them, see if it's the right fit for you, because also it's very beneficial from a tax benefit standpoint, especially if you're going to be raising funds at some point.
Makes sense. You obviously know your stuff, Emmanuel. And, if anybody has any questions, I'm sure we'll share your information later and put that in the show notes to learn more. Uh, Getting towards the end here, and before we wrap, I want to come to one of my favorite parts of every episode, which is the checklist. And so we have a 5-step checklist for any exit ready foundation to have that exit ready foundation in place. So I'll read off each of the five, and then if you just add in some color commentary, that Emmanuel, you ready?
Sure.
All right, let's go. So number one, coming back to it, is clean your corporate cap table.
Yeah, ensure first of all, don't make any equity promises that aren't in writing. Second of all, ensure every equity promise is documented in writing. Handshake deals for equity, those are the fastest way to derail your acquisition.
It makes a lot of sense. Number two, prioritize IP ownership.
Yeah, confirm all founders, employees, contractors, and again, even founders have signed intellectual property assignments so the company actually owns its own secret sauce.
Love it. Makes sense. Number three, audit your material contracts.
Again, make sure you have those material contracts in writing, first of all. Look if you have auto renewal provisions. Those can be very, very useful and valuable for you, especially for those bigger contracts. Review your client vendor agreements for change of control clauses if you're ever planning on doing an equity sale, or assignment provisions if it'll be an asset purchase, allowing you to sign the deal. That way, no third party has any power over your exit.
Number four, formalize your board governance.
So, for this one, even if you're small, act like you're a big company with regular minutes, regular resolutions, makes you look significantly more professional and to sophisticated buyers.
Makes sense. I love that. Number five, last but not least, ditch the stuffy, but keep the precision.
So, for this, find a legal partner who understands your entrepreneurial pace, but won't compromise the technical details of security law. A lot of business owners, founders, entrepreneurs, they're quick. They need to get to the point. They need to remove the stuffiness, just have that conversation one on one. And that's what we like to do.
Love it. Love it. Emmanuel, this was awesome. So much great information. Thank you so much for joining me here today at the search bar. It's really refreshing to see a legal practice that prioritizes the dreamer, right? And kind of helping support the entrepreneurs as they're moving fast, just as much as the deal. Before we wrap, can you share where listeners can find you, learn more about the entrepreneur lawyers, and how maybe they can reach out to you for that next big move?
Of course. So the best place to find me is on LinkedIn. I'm pretty active there. I post regularly about M&A trends, private securities, general corporate law issues that come up. And the firm name is The Entrepreneur Lawyers. That doesn't give away what we do pretty easily. Our website is theentrepreneurlawyers.com. If somebody wants to reach out directly, you can find my contact information there. It might be a little easier than spelling my last name. But I work with founders and business owners at any stage. I am licensed in California and Florida. I would have clients internationally, so long as they're operating, they typically acquire businesses in the States or are starting funds in the States. My deals happen nationally. So whether you're forming your entity or getting ready to run a process, please don't hesitate to reach out.
Awesome, Emmanuel. Thank you so much for being here. Absolute pleasure. And for our listeners, viewers out there, if you're ready to scale smarter, not harder, book your free discovery session through our Motion for Marketing Success System. The link is in the show notes. Until next time, stay curious, stay grounded, and keep building a law practice you genuinely love. Emmanuel, thank you again.
Thank you so much, Eric.